Değerli katılımcılar, hepiniz hoş geldiniz Grup Ofis Marka günlerine. Bugün Heather Williams'la beraberiz, Marks & Clark'in partnerlerinden ve Brexit sonrasında markaların Avrupa Birliği'nde tescil edilmiş ya da hali hazırda devam eden markaların ve tasarımların durumlarıyla alakalı olarak, bunların gelecekteki atılması gereken adımlarla ilgili olarak bizleri aydınlatacak. Sunuma başlamadan önce birkaç hatırlatmayla başlamak istiyorum. Birincisi, toplantımız kayıt altında olacak. Sol üst köşede recording kısmından görebileceğiniz gibi. Soru cevap kısımlarında alakalı olarak alt tarafta chat noktasını göreceksiniz. Chat kısmından sorularınızı bize zamanı da etkin kullanmak adına webinarın sonunda iletmenizi rica edeceğiz. Eğer sunum esnasında bir sorunuz olursa bunu Heather'ın sunumunun sonunda dikkate alarak kendisine ileteceğiz. Simultane çeviri ile birlikte bu sunumu sizlere aktarıyor olacağız. Alt tarafta interpretation kısmından takip etmek istediğiniz dili seçerek İngilizce ya da Türkçe olarak sunumu takip edebilirsiniz. Zaten alt taraftaki chat kısmından da görebileceksiniz. Tanım, biraz da bilgilendirme yaptılar arkadaşlar sizlere. Ve Mute Original Audio kısmını seçerek sadece istediğiniz dilde dinleme seçeneğinizi bu şekilde sağlayabilirsiniz. Aynı zamanda şu anda Türkçe kanala geçerek takip edebilirsiniz sunumu. Ben İngilizce kanaldan girişi yapıyorum. Hello Heather. Your microphone is closed. You can open your mic.
Hi, Graham, that's better.
Welcome to Grup Ofis Trademark Days. And so firstly, I hope all of you and your families are safe. As you know, we have experienced a very bad year, and this year we are full of hope because hope is always the most important element for us to hold on to life. Today on our webinar, we will discuss Brexit and its effects to intellectual property and also its effects to European Union trademarks and designs. After United Kingdom has departed EU, there are some actions that European Union trademark or design applicants or holders must take. Today, we are with Heather Williams, partner of Marks & Clark, a well-regarded company which headquarters is in the United Kingdom. Heather will enlighten us about the steps that must be taken in order to extend the protection of IP rights to UK. Heather, we are all ears. You could share us your presentation.
Thank you, Karim. Okay, thank you very much for the kind introduction and for inviting me to speak on Brexit and the implications that it has on trademarks, focusing on EU TMs and EU designations of international registrations, which during the course of the presentation I will refer collectively as EU trademark rights. So we'll cover off the key impacts, we'll go through the creation of the trademarks and some issues affecting the newly created rights, and I'll weave into the presentation some helpful hints and tips that are relevant to trademark practice in the UK that are specifically relevant to the new comparable trademarks. Now, as I'm sure you will be aware, the UK actually formally left the EU some time ago now. It was actually on the 31st of January 2020, but actually nothing really changed in the UK until the end of the Brexit transition period, which was on the 31st of December last year. So from the 1st of January this year, the UK is now no longer treated as being part of the EU, and this has important implications for IP owners, and today we're looking at the impact specifically on brand owners. So the main impact is clearly that EU trademark rights are no longer conferring any trademark protection in the UK. And this therefore means that any EUTM rights cannot be relied on to challenge any infringing use in the UK or oppose a conflicting trademark application in the UK. So businesses that are interested in protecting their brand both in the EU and UK going forwards will need to file separate trademark applications. However, for those businesses that were able to secure EU trademark rights that were registered by the 31st of December last year, they will benefit from continuity of protection in the UK because they will have received a comparable cloned right in the UK. So let's look at the comparable rights in more detail. So on the 1st of January this year, the UK IPO automatically created comparable trademarks for all EUTMs and EU designations of international registrations that were registered by the end of last year. The key issues to be aware of is that these rights have been created automatically without the need to pay any fees. The new rights are entirely independent and can be assigned, licensed and renewed separately from the EU rights. They will also enjoy the same legal status as if they had been applied for under UK law. But it's important to remember that comparable trademarks actually benefit from special grace periods around proving genuine use and reputation in the UK, at least in the short term. An important issue to be aware of is that the newly created rights will retain the same filing date and the same filing number with a set prefix depending on how the EU right was obtained. So comparable trademarks that are created from nationally filed EUTMs will have the prefix UK 009 followed by the EUTM filing number, whereas comparable trademarks that are created from EU designations under the Madrid will have the prefix UK 008 followed by the last 8 digits of the international registration number. So it will therefore be straightforward to identify the newly created rights, and this is important to know because the UK IPO will not be issuing any registration certificates for the new rights. The final point on the slide is that it is possible to opt out of holding a comparable right. And whilst we don't expect to be flooded with requests for owners to opt out of receiving a free right, it may be appropriate in certain circumstances. So for example, it may be appropriate to opt out if a rights holder would be in breach of a settlement agreement if they were to own a UK trademark registration. So administration of new rights, who is responsible? So the comparable rights have pulled across much of the information that was recorded on EU rights, and that includes the address for service details. So the address for service of comparable rights will be the same as nationally filed EUTMs. However, as it's not a requirement to list an address for service in an EU designation of an international registration, unless there's been an issue during the prosecution of that EU designation, the comparable right will not have any address for service recorded. So therefore, if you are a user of the Madrid system, it's important to review and identify the relevant cases because you could find that you have comparable rights without any address for service recorded. Another issue to be aware of is that by default, many European firms who do not have offices in the UK or UK qualified lawyers will be the address for service for many comparable trademarks. And this is perhaps not ideal as they will be unfamiliar with UK trademark law and practice. So we do recommend that you review your comparable trademarks to make sure there is a representative, but also that the representative recorded is appropriate. One of the big implications of Brexit is that there is an increase in administration in the management of these new rights, making sure they have an address for service. So I've added this point in cases of interest. which is that we will add details of comparable trademarks to our system, appoint ourselves as address for service without incurring any costs. The final point on the slide is that the rules on UK address for service have changed, but they won't immediately impact on holders of comparable trademarks. So what that means is the withdrawal agreement that the UK and EU entered into provides that holders of comparable trademarks have a 3-year grace period within which to update the address for service to comply with the rules. Now, there is an exception to that point, and we'll come on to that. So previously, the address for service rules were that anyone that was located in the EEA could be the address for service. However, the rules changed on the 1st of January, which means that, again, subject to a number of exceptions, any new UK trademark applications, opposition, cancellation actions need to have a UK address for service. And that address can include an address in Gibraltar or the Channel Islands. Now, as I mentioned, there are exclusions to this address for service rule. So certain actions before the UK register don't require a UK address for service, and these are attending to a renewal, surrendering a trademark, or updating an address, or correcting an error or omission. The second exception that I've listed is that where trademark applications were filed or proceedings commenced, such as opposition or cancellation actions, prior to the 1st of January, again, the new rules don't apply to those proceedings or pending applications. The final exclusion, which we've mentioned, is in relation to comparable trademarks. They have this 3-year grace period. Now, the exception that I mentioned is if during the 3-year period, a challenge is made to a comparable trademark, which has been created from an EU designation, such as a cancellation action. In that situation, it will be necessary to instruct a UK representative to manage that process. If the same were true for the comparable trademark created from the EUTM, then it wouldn't be necessary to appoint a UK address for service. So there is a bit of a strange distinction, but it's there, and I just wanted to give you the full picture so you have the full information. So turning now to look at EUTMs. So as we know, if you were the owner of a pending EU right, you will not have received a comparable trademark. But there is this 9-month grace period to file for a corresponding application in the UK. And the grace period runs from the 1st of January 2021 to the 30th of September 2021. And as I've mentioned, following the change of address for service rules, you will need a UK address for service for any corresponding application. The applications for comparable trademarks must meet certain formality requirements in order to retain the same EUTM filing date akin to priority. So what that means is you need to make sure the application is for the same trademark in the name of the same owner and be for the same goods or services or narrower goods or services. Applications for comparable trademarks will be examined and published according to UK law, and UK official fees will apply. And an important point to bear in mind is that the EU IPO is unlikely to issue any notifications to rights holders of pending applications to remind them of the need to file in the UK if desired. So what we would say is if you had any pending applications at the relevant date, so the 31st of December, that you make sure you diarise this deadline to file for a corresponding right, because nobody else will be reminding you of this date. We've covered some of the issues already on this slide, but I thought it was important to have a separate slide dealing specifically with EU designations of international registrations, just to labour some of the really important points. So comparable rights that have been created from EU designations will be national and independent from the international registration. As I've mentioned, unless it's come up during the course of the prosecution of the EU designation, the comparable right will not have any address for service. So it's important to look at that and appoint an address for service if appropriate. It follows that any EU designations that were pending as of last year will not receive a UK comparable right, but rights holders can apply for a corresponding application before the UK IPO. It's an important point to remember is To retain the filing date of the EU designation, the application for a corresponding application must be made before the UK IPO and not before WIPO. There is a procedure for opting back into the Madrid system if rights holders want to take advantage of the centralised management of the Madrid system. This isn't a Brexit workaround. This is a procedure under the Madrid Protocol, which is known as replacement. So what's involved here is that the rights holder will need to file for a subsequent UK designation, which will be examined and published. Registration is not automatic and official fees again will be applicable. Once a statement of grant of protection has been issued, the rights holder can request that the UK IPO make a note in its register that the UK comparable trademark has been replaced by the international registration, by the UK designation in the international registration. The UK IPO will examine that request and assuming it meets the formality requirements, which is akin to a seniority claim, will notify WIPO that the UK comparable trademark has been replaced by the international registration, and this will then be published on the IR register. I don't anticipate this will be used very often, but it's an option. Turning now to look at disputes. So opposition and cancellation actions based on EU rights or other national EU rights will not be impacted by Brexit. However, pending opposition or cancellation actions, which are based solely on UK trademark rights, will fall away from the 1st of January and onwards. An important point to bear in mind that cancellation actions which were pending against EU rights as of the 31st of December could impact on the UK comparable trademark. So when a decision is issued, it's important to review that decision to see if the grounds would be equally applicable to the UK comparable trademark. And it's an important point because the UK IPO has said it will honour the result of cancellation decisions in that instance. However, if it doesn't apply to the UK trademark, then it may be necessary, if it's appropriate for you, to file a separate cancellation action against that comparable trademark. So as we've touched on already, pending EU trademark applications will not receive a comparable trademark, and that applies if your EU application is under opposition at the relevant date. If you are an opponent of an EU right, you may also wish to set up a watch so that you are notified of any applications that are filed during the grace period, so you can file oppositions if appropriate. And the last point there on the slide is that the UK can no longer, a UK trademark can no longer be used to oppose or challenge EU rights. Turning now to look at disputes before the UK IPO. And in actual fact, Brexit has little impact on these types of disputes. And this is because holders of registered EU rights have received a comparable trademark, so pending trademark opposition and cancellation actions will simply continue. There is one exception, of course, and this is where if you have an opposition to a UK trademark, which is based on a EU right which is pending, those proceedings may be stayed pending the expiry of the 9-month grace period or until the opponent has filed for a corresponding UK trademark application. The final point on the slide, which comes as no surprise, is that EU rights can no longer be used to oppose a UK trademark or challenge use in the UK. Now turning to renewals, which we think is a particular area of risk, as these newly created rights could be allowed to inadvertently lapse through non-renewal. This in itself is quite a big subject, so I'm going to focus on providing you some of the key issues to be aware of. So what will happen is that the newly created comparable rights will retain the same renewal date as the EUTM, but will be subject to separate renewals, apart from one exception, which we'll come on to. So the first issue that I wanted to flag is that where you have an EU trademark had a renewal date from the 1st of January this year, but was renewed during the Brexit transition period, that renewal action is not effective in renewing the comparable trademark. If that situation has happened to any of your rights, then it will be necessary to renew that comparable trademark to keep it in force. The other issue that I wanted to flag, which is important to be aware of, is that where you have an EU trademark, there is lapsed in the 6 months preceding the 1st of January this year, the UK IPO will still have created a UK comparable trademark, which will hold an expired status. Now, where that EUTM is renewed in the 6-month grace period, that renewal action will be effective in renewing the UK comparable trademark. So that's the exception to the rule. But in this scenario, it's not possible to renew the UK comparable trademark separately. Its maintenance is dependent upon that EUTM that lapsed prior to the end of the Brexit transition period. The final important point is that the UK IPO is operating a change of procedure in respect of renewals in the first 6 months of this year in dealing with renewals of comparable trademarks. So what will happen is that the UK IPO will issue a notification to the rights holder or their representative on the day that the right expires or soon after, which will set a 6-month deadline to renew. No late renewal fees will be payable. It's just you will just have a shorter window within which to maintain that right if it's one that you wish to maintain in the UK. So renewals is an area of risk because they don't necessarily have been captured on rights that have only recently been created, and not everyone is necessarily familiar with some of the renewals that are applicable to comparable trademarks. So I thought it would be useful to go through some hints and tips. We've already touched on some of these already. So the first is just to make sure that you diarise this 9-month Brexit deadline to file for corresponding applications. And likewise, if you're an opponent, to make sure you're monitoring for applications so you can file oppositions if that's appropriate. The second point is to docket any relevant renewal deadlines. So once you have your portfolio of comparable trademarks, just to make you or your UK representatives review to make sure you're not missing any important dates, paying particular attention to any EU rights that were renewed early during the Brexit transition period. The third point is to make sure that where you wish to secure trademark rights, both in the UK and EU, that you budget for the additional cost of having to file those separate trademark applications. The fourth point is in relation to updating the register, which ideally should have been done before the end of the transition period. The reason I've kept this on the slide is just to make the point that actually when you come to do recordal updates, it's now necessary to file a recordal application both at the EU IPO or WIPO if it's an EU designation and the UK register separately if you didn't manage to get around to doing that before the end of the transition period. If you haven't done already, it's also worthwhile checking IP agreements to ensure that they continue to cover the UK if that's the intention by reference to the definition of the EU. And the final point on the slide is in relation to reviewing comparable trademarks in the context of checking the address for service. So care here needs to be taken to ensure address for service in respect of comparable trademarks created from those EU designations, but also in relation to checking that the address for service is appropriate and has perhaps the UK representative listed. So this final slide is just really quickly how we at Marks & Clark can help. So we have European coverage. Thankfully, we are not affected by Brexit. We have teams in France, Luxembourg and UK, which make up a European team. So we can continue to act both before the UK IPO and EU IPO without any disruption or increasing costs for our clients. As I mentioned already, we can remove the admin burden by taking on the details of the new rights, diarise those important renewal deadlines and advise of any action to maintain the UK trademarks, and of course deal with the UK IPO representation without incurring any cost to you or clients. And the final point on there is that if we do take on those comparable trademarks, we will, as a matter of course, monitor any of the important deadlines that we've discussed during the presentation. So that brings me to the end of the presentation, which I hope you found useful. As Prem said, I'm very happy to take questions, but I've also indicated my email address and happy to respond to any questions over email as well. So thank you very much.
You're welcome, Heather. We also would like to thank you for the presentation. And so I would like to also remind our attendees, they could ask their questions under the window. There's a chat part, and on that part they could type their questions, and we will be more than happy to answer. But first, I could start with my question. Actually, most of the European Union applications from Turkey are filed through Madrid Protocol by selecting European Union section. About the trademark renewals, for example, some of our clients could have a registration by selecting EU. What will be the future of those renewals? Do they have to file a separate renewal and pay a separate renewal fee for United Kingdom as well as their payments through Madrid Protocol? And my second question is, please, also I could have your confirmation that there will be no problem for the applicants to select United Kingdom separately with an addition of European Union in the past, of course.
Okay, thanks, Rem. Good questions. In terms of the first question, so where you have an international registration, you've designated the EU, the future maintenance of that UK comparable trademark will need to be maintained separately. So it will be the case that the rights holder will need to attend to the renewal at WIPO to maintain the international registration, but also pay a separate renewal fee to maintain that UK registration. So ultimately, it will lead to an increase in cost for rights holders. In terms of the second question, there is no issue in terms of for future applications to designate the EU and UK separately within a Madrid Protocol application. Does that answer your question?
Yeah, yes, of course. Thank you very much. I'm not looking at the questions, but it seems that this session, this webinar has been very fruitful for everybody. And thank you very much. So thank you very much for the presentation, and that has enlightened us. And I also wish you and your families and your organization a very good and fruitful and healthy new year.
Thank you. It's great. It's been a pleasure to be here. Thanks for having me.
Thank you very much. Take care.